So starting off with the legislative background, the Serious Crime Act 2015 amended the Proceedings of Crime Act 2002, inserting Section 10A, which allows the court to take the interests of other parties into account at an earlier stage in proceedings than was possible under the old scheme. It's important as a starting point to remember that under the Proceedings of Crime Act 2002, a confiscation order is made against a defendant rather than against any assets, though these are obviously accounted for when the court is considering the available amount. A defendant could, though, in theory, pay off a confiscation order with whatever assets he or she has available. The reality, though, is that the available assets that are identified in confiscation proceedings, particularly property, so for example, the family home, will usually be used to satisfy confiscation orders, and therefore questions about ownership of these assets are engaged. So turning over to the next slide, just to look at the other provision which was referred to by the court in Hayes, section 81 of the Proceedings of Crime Act. That provision sets out the rules relating to the value of tainted gifts, and you can look at that in your own time. But to conclude with Hayes, what the court ultimately decided in that case was that the transfer of interest in the property in question was a tainted gift, that there was no monetary consideration, and that the contribution to the home, so this is the argument about domestic contributions, had to be placed in the context of the defendant paying the bills, which effectively balanced everything out. So it couldn't really be said in that context to have been meaningful consideration. So arguably quite a conservative approach taken in the case of Hayes. And you'll see in due course when we look at other cases that the approach can be quite different depending on the factual circumstances and whether tainted gift provisions are engaged.